Assalamualaikum and hi everyone. My name is Tunilong Saribint Azmir, metro number 265076, and today I'm going to present about informative speech. Martin Luther King Jr. once said, "Injustice anywhere is a threat to justice everywhere." Nowadays, the court is a place to adjudicate the legal disputes between parties, as it is generally understood that all people have the right to bring their claims before a court. However, the court could not cater too much case in one time. This will cause a backlog of cases, and therefore, this is when people will opt for alternative dispute resolution. Alternative dispute resolution is a wide range of resolution process that aims to resolve disputes speedily and cost efficiently. For your information, I'm a student of Bachelor of Law. I studied the paper of Malaysian legal system, and I'm here to inform you and widen your perspective on the legal mechanism in attaining justice. There are three alternative dispute resolution in the Malaysian legal system, namely arbitration, mediation, and adjudication. So, let us start with the most similar to the court system, which is arbitration. Firstly, arbitration is generally seen as more flexible procedure than litigation, but this may be so in theory, but not in practice. According to Holtham et al. In 1999, the advantages of arbitration is that the parties have freedom in appointing the arbitrator to hear the case. However, the downside is that it can be seen that lawyers are taking advantage towards the parties in terms of the way of conducting the hearing, which costs more time consuming on something that should be brief and short. Holtham in 1999 also stated that the parties have the freedom in choosing the rules and regulation with high flexibility of procedural and substantive law. However, the overall process may cause a lack of certainty and hesitancy among the parties. The parties should have discussion in deciding whether to have arbitration process over litigation, as well as to know the end result of their decision, as the decision will only be made once both parties have consensus. Besides, Bataspa in 2003 views that arbitration can be very quick and effective as a means of resolving disputes. The most popular reason for the parties to opt for arbitration is that it has lower costs to be compared to the court costs. Even though both arbitration and litigation have expensive costs, however, it can be said that it is worth it. It cannot be denied that the process of arbitration is much more speedier than the court. This is because arbitration only focuses on one case at a time, while the court deals with numerous cases in one day. In my opinion, the parties should opt for arbitration over litigation due to its flexibility, quick, cost-effective, and also easier for both parties to reach to an agreement. Furthermore, mediation is also one of the easiest methods in resolving disputes. A research report published by Zuhairah in 2010 stated that mediation is an alternative which creates a non-adversarial condition to reach a win-win situation. Based on the report, the author mentioned that the adversarial characteristic of mediation encourages the parties to reach the best solution for everyone and also help maintain a business resolution. The best resolution here carries the meaning that the decision of the mediator in the process of mediation is not binding on the parties, and it only acts as a medium to discuss the dispute between the parties. The third party, which is the mediator, is a neutral person that does not make decision on the dispute, but rather only listen to both parties. Best Buy in 2003 stated that the function of mediator here is to assist the parties in dispute to generate options and foster understanding of their respective position and also manage their emotion. The discussion, or as known as mediation, is solely for the parties to explain in detail and to reach an amicable agreement between them. Besides that, Best Buy in 2003 stated that the concept of mediation is completely in contrast to arbitration. Mediation is different from arbitration as well as litigation in terms of the cost, time, and decision. The cost to hire a mediator is far lower than the price to hire an arbitrator. Next, mediation is faster and speedier than arbitration as it does not include the strict rules and also the binding decisions. According to Mr. List in 2001, although the mediator controls the process of mediation, he or she does not impose any resolution or opinion on the merits of the case, promoting win-win situation, leaving the parties themselves to control the outcome. In my opinion, mediation offers the lowest commitment of all parties, however guarantees a good and promising end result. Thus, I suggest for all parties to opt for mediation for a lower cost, faster resolution, and also flexibility in decision making. Well, that's the benefit of mediation. Now, let us move on to the next, which is adjudication. Lastly, the alternative dispute resolution, which is the nearest process to arbitration, is adjudication. Best Buy in 2003 stated that adjudication is similar to arbitration in that it is a judicial process in which the adjudicator determines the parties' respective rights and obligations under the contract on the basis of the evidence presented on the parties. Adjudication can be differentiated to mediation in terms of the decision made is not only temporarily binding and not finalized until it is brought to be reviewed by the litigation, arbitration, or settlement agreement between the parties. This means parties does not necessarily have to obey all the decisions made by the adjudicator who acts as the third party. And if any parties does not agree to the decision made by the adjudicator, they are allowed to bring the case to other alternative or to the court. The process of adjudication is much straightforward than arbitration and has a similar speed process as mediation and also somewhat low in cost. Undoubtedly, the process of adjudication is less complicated to be compared to arbitration as the adjudicator need to make decisions within limited time. According to Undang-Undang Singgam and Sabaratnam in 1998, in Malaysia, the use of adjudication to resolve dispute is rare. Danuri in 2012 stated in his report titled A Revisit on the Current Practice of Dispute Resolution and ADR in the Malaysian Construction Industry, Malaysia still do not have its own statutory adjudication, unlike in other countries such as UK, Australia, New Zealand, and Singapore, which is binding and regulated by an act. From my point of view, adjudication is the best choice for those who want to refer their dispute to the law expert for an expensive and quicker process. Besides, they also have the freedom not to comply with the concluding decisions. So, that's all the information that I want to share with you guys about alternative dispute resolution. Besides filing your case to the court, you must know that there are 3 alternative dispute resolution under the Malaysian legal system, namely mediation, adjudication, and also arbitration to resolve your disputes. If you prefer a less prolonged, tiresome, difficult, and costly procedure, please do consider the alternatives provided. Thank you for listening, everyone. Have a good day, and Assalamualaikum. Now, let us move on to the next, which is adjudication.